group of amendments looks at the treatment of legal content accessed by adults. And the very fact that Parliament feels that legislation has a place in policing access to legal material is, I think, itself worrying. This was, of course, initially a door opened by the government in the initial draft bill, but as we've already heard, after widespread civil liberties backlash against the legal but harmful clauses, we're left with clause 65. And of course, I'm worried, as has been mentioned, that this clause, and indeed some of the amendments, might well bring back legal but harmful for adults by the back door. And one of the weasel words here is harmful, but as I've indicated before, it's quite difficult to work out in terms of the groupings when to raise which bits. So I'm keeping that for you till later. Just to note that I'm rather nervous about the weasel word harmful. But anyway, like many others, I cheered at the removal of the legal but harmful provisions, but I do have serious reservations about its replacement of further duties via terms of service, which imposes a duty on Category 1 services to have systems and processes in place to take down or restrict access to content, to ban or suspend users in accordance with terms of service, as the Noble Lord Moylan has explained. And it's one of the reasons I support his amendment, because it does seem to me to be the state outsourcing the grubby job of censorship to private multinational companies with little regard for UK law. I put my name down to Lord Moylan's Amendment 155 because I wanted to kind of probe what the government's view is on our attitude to companies' terms of service. I mean, platforms have no obligation to align their terms of service with freedom of expression in terms of UK law. It's up to them. I'm not trying to impose upon them what they do with their service users. If a particular platform wishes to say we don't want these type of views on our platform, fine. That's their choice. But when major platforms' terms of service, which are extensive, now become the basis on which UK law enforces speech, then I get nervous, because state regulators are to be given the role of ensuring that all types of lawful speech are suppressed online, because the duty applies to all terms of service, whatever they are, regarding the platform's policies on speech suppression, censorship, user suspension and bans and so on. This duty is not restricted to so-called harmful content. It's whatever content the platform wishes to censor. What's more, Clause 65 asks Ofcom to ensure that individuals who express lawful speech are suspended or banned from platforms if in breach of the platform's T's and C's. And that means limiting those individuals in expressing themselves more widely beyond the specific speech in question. And that's a huge green light to interfere in UK citizens' freedom of expression, in my opinion. I want to stress, I'm not interested in interfering in the terms and conditions of private companies, although you'll see later that I've got an amendment demanding that they actually introduce free speech clauses. But that's because the way that we are seemingly enacting the law is via the terms of service of private companies. They should, of course, be free to dictate their own terms of service. It's reasonable that members of the public should know what they are, expect them to be upheld, and so on. But that doesn't justify the transformation of these private agreements into statutory duties, and that's my concern. So I want to ask the Minister, why are we allowing this bill to ask companies to enforce censorship policies in the virtual public square that do not exist in UK law? When terms of services permit suppression of speech, that's up to them. But when they suppress speech far beyond the limitations of speech in UK law, and then they are enforced to do so by a government agency, as in, or regulator, as in Ofcom, aren't we in trouble? It means that corporate service, terms of service, which, by the way, are designed to protect platforms' business interests, are they not, are trumping case law on free speech that's involved for many years. Those terms of service are also frequently in change and in flux according to fashion or ownership. One only has to look at the endless arguments about the, and I yet to understand it, the changing terms of services in relation to Twitter after the Elon Musk takeover. Is Ofcom's job to follow Elon Musk's ever-changing terms of service and enforce it on the British public as though this is law? The T's and C's no longer are therefore simply a contract between the company and the user, but having been brought under statute, it means that big tech will be exercising public law functions, with Ofcom the enforcer, ensuring that lawful speech is suppressed constantly in line with private companies' terms of service. This seems to me to be an utter mess, not in any way adequate at protecting free speech, and really a fudge by the government because they were unpopular on lawful but harmful, so they've simply outsourced it to someone else to do the dirty work.
Well, my lords, I